Namaste. So now we move on to the most crucial section of general exceptions, all right? And this perhaps will clarify a lot of things. In fact, this is the section based on which the entire general exceptions is basically, you can say in Hindi, it is tickled on. इसी पे सब कुछ टिका हुआ है. So this section, whenever you're writing an answer on general exceptions, I'm going to tell you what all to mention, but this is crucial, all right? So 84 deals with insanity or mental abnormality. And as I've told you, anything that you do in the IPC, actus and mens rea, so basically, as soon as we say mental abnormality or insanity, you can pretty much, you can pretty much think where this is going, right? And where is this going? Insanity or mental abnormality? The person doesn't have the mental capacity to form mens rea. So if he cannot form an intention, remember in the IPC we are punishing you for two things. Just because you have a guilty intention, we all do, right? We all do. But you don't act on it, the IPC cannot punish you for it, correct? Mostly. And then under the strict liability offenses, of course, you just do the act and well, you're gone. So even if your intention is there, it's not there, we really don't care, right? But herein, the act will be performed, that is for sure, but you don't have the mental capacity to form an intention, and this is pretty much the core crux of the IPC. And this is what this section also says. So I'm not going to read out the entire section to you. I'm going to break it down and give you the necessary ingredients. Homework for you is, well, obviously, you see, this course doesn't work without a bare act any which way. So you're going to read this section from the bare act. So nothing is an offense which is done by the person who at the time of doing it, crucial. This is pretty much the sentence that sums the section up, all right? Who at the time of doing it by reason of unsoundness of mind. So what is the reason here? That your mind is unsound. If your mind is unsound, how exactly are you forming the mens rea? You just cannot, you are incapable, right? So it is nothing is an offense basically if you're a lunatic who did that act, and since you have committed that act, you will just not know, that what is the effect of that act. So how do we punish you, right? Punishing you then will violate the very core concept of justice as it's given where? Preamble. Okay, everything actually boils down to the preamble. You can pretty much connect everything to words of the Constitution, but let's get to that later in the Constitution section of the course. Is incapable of knowing the nature of the act. उस बेचारे को पता ही नहीं है कि उसने किया क्या है. Let us say that I am a person of unsound mind, and again I'll just use my remote, and I think, well, I'm under a massive delusion, hallucination. I live in my own world permanently, and I think, this is a soft toy, that this is a teddy bear. I just throw it at you, and this sharp pointed thing, I don't know whether you can see this properly or not. This pretty much has the capacity to kill someone, to hit someone in the eye, whatever it is. Presumably, let us say that this is a dagger, and well, it kills you. Okay. तो मैंने क्या किया था जी? मैंने ये किया था that I thought, let me just throw it. It's going to tickle you, whatever it is. But what actually happened? It ended up killing the other person. Was my intention to have fun with the other person, or was my intention to kill the other person? My intention was to have fun, right? We're just, playing around, fooling around. But, अरे बाप रे बाप, ये क्या हो गया? So this person died, and I still don't know even after his death, I'm a person of unsound mind. So how exactly can you prosecute me, right? But this has to happen at the time of doing the act. So you can be a lunatic before the act, you can be a lunatic after the act, we don't care. What state were you in at the time of doing the act? That is the most important, all right? So law presumes that a madman has no will. Make a short point. And this is the language that you will use in your answer. Incapable of forming criminal intent. Alright. Another thing that you're going to write in your answer is Section 105 Indian Evidence Act, illustration A. Illustration A, because it talks about burden of proof, and I'll just put it on the screen here, the illustration, basically the screenshot. And if you can remember this, so remember in the law optional we aren't exactly testing you on your word to word memory power of the section and the illustration, but if you mention Section 105 illustration A and the core crux of the illustration, that works. So don't be a fanatic that oh मेरा may इधर चला गया, वो उसने तो A लिखा था, मैंने किसी का नाम लिख दिया in the illustration. Don't worry about those things. Worry about the core concept. Remember, we are demonstrating to the examiner that we have understood the concept and we know why law is, well, the way it is. Alright. Another thing that you will mention in your answer whenever it's 84, it's the M. Nathan case. So you can basically इसको याद कैसे करते हैं, मैकनाटन कर लेते हैं, लेकिन मैक नहीं है उसमें, C नहीं है. This is M. Nathan case. So M. Nathan case में क्या हुआ था? The accused thought that the UK Prime Minister was troubling him, and because he was a person of unsound mind, so he thought that the UK Prime Minister had actually assaulted him. So he shot dead his secretary, but he presumed the secretary to be the PM. It was not the PM, but then he thought that this guy was the PM and he shot him. So he shot the secretary. Alright. So in that, certain amount of rules in England were propounded for the purposes of a person with insanity or mental abnormality कि इनके साथ आप करें तो करें क्या. Alright. And these rules, basically, you need not get into the rules. These rules are explicitly hard coded into Section 84. So Section 84 basically enshrines these rules, alright. So 84 के अंदर ये सब already दिया हुआ है. So just mention a quick brief of this. You need not, again, if you can remember, great, but then since you're already preparing for the UPSC, you have like another 10 trillion tons of information to remember. If you can just explain this is great. If you can remember the names, even great, but if you cannot remember, it is absolutely okay. What can you not remember? The names, that is. अब यहाँ पे जी कौन से यूके के प्राइम मिनिस्टर क्लेमेंट एटली की तो बात हो नहीं रही यहाँ पर, तो किसी और भैया की बात हो रही है, and then secretary is also accused is also. So let it be. Just explain the situation, and whenever you cannot remember the names, so be smarter. In law, be smarter. And how exactly are you going to be smarter? You're going to tell the examiner, the accused thought the UK PM. So you're going to basically cover it up. The accused killed the PM secretary under unsoundness of mind, under the impression that he was the PM, and basically shot him dead. The rules propounded in that case are actually given in 84, and these pretty much are those rules. Obviously in different language, but pretty much the same thing. The core concept is the same. Alright. So M. Nathan case, which gave those rules, are given in 84. लिखना ही लिखना है. No way that you can skip it. अभी आ रहे हैं यहाँ पे हमने और क्या क्या crucial लिखना है, उस पे हम फिर we're going to revise it. So in another point that you can mention is insanity prior or subsequent to the event. It does not matter. Alright, it absolutely does not matter. You can be like, for example, let us say that a person of unsound mind takes this defense that he has been insane from birth, but let us say that he was cured and then he commits the act. Can he take the benefit of 84? Sorry. And let us say that so a certain person commits one act and then subsequent to that act, that person goes insane. Can you? Sorry. So insanity prior or subsequent does not matter. Achha, why? At the time of doing it. Correct? वहीं तो लिखा है, इसीलिए ये arrow बनाई हुई है, at the time of doing it. Right? This is the crucial ingredient of this section that you must mention so that the examiner knows, well, we know, alright. Insanity during intervals. मान लेते हैं आज आप पागल हैं, tomorrow you are fine, then later on the next day again you lose your soundness of mind. Can you take section 84 की defense? Yes, provided that at the time of doing the act, tada, you were a person of unsound mind. Okay. Now, Jaidal versus Delhi administration is the case law that you can mention. So write it in your case law list, especially make a list for IPC. Make a list as we go along the course. I'm telling you basically what all to do. So Jaidal versus Delhi administration. If basically the accused was a person with schizophrenia, but he was treated and cured, and then he stabbed a 1.5-year-old child who subsequently died. He hid the knife, he locked the doors, he prevented arrest, and he, in fact, people who came after him, he even threw bricks at them. Does it seem like a case of a lunatic person? Does it? This is very planned, the intention is clear, the motives are clear, you are hiding the knife, you're running away, and specifically you were treated and cured. So at the time of doing it, आपकी sorry हो चुकी थी ना? You were alright? Sorry, you cannot take the plea of 84. Okay. Now, what all you have to write and remember, till the time that I'm not done with general exceptions, in fact, throughout the course, what we are going to do is we're going to repeat stuff. We're going to repeat it so many times that it gets drilled into your head. So 105 IEA mention karna hi karna hai with every answer. Section 6 of the IPC. Whenever you're writing with every answer, obviously I'm referring to answers with respect to general exceptions. Section 6 of the IPC you cannot skip, buddy. Article 361. Let the examiner know that we know a certain exception to the criminal liability exists. 105 done. Section 6 IPC done. Now whenever you're writing an answer specifically on 84, you can go in for illustration A as well. If you remember it, if you don't remember it, it's okay. Absolutely fine. But इन चीज़ों पे आप stress करके आएंगे अपने आंसर के अंदर. Section 6 of the IPC is done. All of this is done. अच्छा, chapter 4 क्या है IPC के अंदर? General exceptions. 76 to 106, 96 to 106 is private defenses. 76 to 106 on the whole is general exceptions. Correct? Okay. Watch the previous lectures in the course to revise everything. So Jaidal versus Delhi administration, and then Bikari versus state of UP. No, it's not Bikari, it's Bikari minus H. तो याद करने का अच्छा तरीका. Bikari versus state of UP. The Supreme Court gave certain guidelines. The most crucial of them is that the prosecution की duty क्या है? Basically, if you have to take the defense of this section, so accused will have to take the defense, the burden of proof as per 105 IEA is on who? The accused. But prosecution की duty क्या है? So it's not the prosecution की duty to prove, well, the person was a lunatic. That is the accused's job, right? That is why we have a dedicated section. Prosecution की duty क्या है? To prove beyond reasonable doubt, and this is the language that you are going to use anytime that you write an answer relating to criminal law, law of crimes, beyond reasonable doubt, because that is the crucial thing that we do in a code of law. So you cannot ever अब judge तो third party judge साहब अपने chamber में बैठे, उन्हें क्या पता दुनिया में क्या हो रहा है. So वकीलों की क्या जो job होती है, this is pretty much it, that you come in here and you prove it to us beyond a reasonable doubt your side of the story. So you cannot prove it like point to point unless the evidence is very, very clear, and mostly it is not. So in law of crimes or criminal law, you have to prove it beyond a reasonable doubt so that the judge decides in your favor. All right, that is basically the crucial, you can say, the core of criminal law. So mens rea of who? The accused, कि उसके पास intention थी, prosecution has to prove it beyond a reasonable doubt. This is the duty, and this is what you want to write in this case law, that the Supreme Court held the prosecution's main duty is to prove mens rea beyond reasonable doubt. Accused क्या करने की कोशिश करेगा? Whenever a plea under 84 is made, accused क्या करने की कोशिश करेगा? एक्यूज कहेगा नहीं जी नहीं, आई एम लुनेटिक, एंड many criminal lawyers take a standard defense कि मेरा तो क्लाइंट ही पागल है. So 84 के अंदर nothing is an offense. So prosecution will do what? Prosecution will लेना है. इसकी intention थी. So from the circumstances of the case, the judge साहब can infer ना, and this is the duty of the prosecution to make a case out of such facts and circumstances. कि जी he stabbed the child, the knife was hidden, bricks were thrown, he locked away the door, he prevented arrest, or he basically was resisting arrest. All of this shows that schizophrenia के चक्कर में, remember, by reason of unsoundness of mind, he didn't stab. Okay, got it? Is it clear? So anytime you read general exception section, so reason is explicitly mentioned. So by reason of. Now another thing that you can mention, provided that you can remember it, is this section is actually so special, or rather you can say this scenario is so special because remember, IPC का core funda ही यही है. So we have a dedicated section or dedicated chapter in CRPC. Sections 328 to 339, you don't remember, it doesn't really matter. 328 to 339 is not important. Chapter 25 of CRPC is important, that you tell the examiner that I also know that in CRPC there is a dedicated chapter to trial of persons with insanity or mental abnormality, and what is the correct, basically the correct wording of the chapter? Homework for you. Open it. Open CRPC ki Bare Act. Just have a cursory look at chapter 25. What does it say word to word? Right? The core I've already told you. So this add on to the answer whenever you're discussing 84. Right? And so we're done with 84 now. Let's move on to further sections. I believe now it's a good time to head into sections that deal with intoxication against your will, because if you get intoxicated by your will, well, there is no defense that you can take under general exception chapter 476 to 106 of the IPC. And by the way, this is how you remember. You say it out loud so many times that आपके मंत्र की तरह आपकी जुबान पे वो चीज टिक जाए. Right? And this is what pandits also do. You recite the stotra so many times कि वो अपने आप ही it just flows. Right? But then बार बार रिसाइट करना पड़ता है. चलो एक बार रिसाइट कर लेते हैं. Chapter 25 of CRPC, Article 361, Section 6 of IPC, 76 to 106, and then आपका और क्या बचा है? 105 of the Indian Evidence Act. Illustration A, if you're talking about 84, M. Naden case, right, will mention at the time of doing it by reason of unsoundness of mind. Crucial case. Case laws: Jaidal versus Delhi administration and Bikari versus state of UP without the H. Alright, and yeah, okay, just a slight error, just not Jaidal. That is what I was, in fact, while shooting the video also I thought maybe this is Jailal versus Delhi administration. मैं कहूँ दल कैसे आ रहा है? So Jailal, अब और अच्छे से याद रहेगा. Oh, our teacher made a slight error, right? Jailal versus Delhi administration. Just make a correction in your notes. This is good. Bikari versus state of UP. All right. Now, see you in the next one.